suit seeking to sack the Rivers State sole administrator suffers major setback. Hello viewers and welcome to Infogist TV. A suit filed by an Abuja-based lawyer, Mr. John Mary Gideobi, seeking the sack of the recently appointed sole administrator of Rivers State, Vice Admiral Ibokete Ibas retired, was stalled on Thursday due to the inability to serve some defendants. The development occurred after the plaintiff's counsel, Chimezie Enuka, informed Justice James Omotosho of the Federal High Court in Abuja that he was unable to serve the Zamfara and Bauchi states, who are the 8th and 9th defendants in the suit, with hearing notice of the matter. At the Thursday's proceedings, only the Attorney General of Lagos, Bayelsa, Taraba and Edo were represented in court out of the 36 state governors, Attorney General that were listed as defendants in the suit. Enuka told the court that he would ensure that all the defendants are served on or before April 13th. He therefore sought an adjournment to enable him to do the needful. Justice Omotosho, with the agreement of lawyers in the matter, adjourned the matter until June 11th. The News Agency of Nigeria reports that Gideobi in the suit marked FHC/ABJCS 572/2025 listed President Bola Ahmed Tinubu as the first defendant. He also named Attorney General of the Federation, the Vice Admiral Ibas retired, and Attorney Generals of the 36 states of Federation as the second to 39 defendants respectively. The plaintiffs in the suit is praying the court to set aside all actions and decisions howsoever described or made of the third defendants, Vice Admiral Ibas retired, in the name of sole administrator of Rivers State, same being unconstitutional, null, and of no constitutional force throughout the Federal Republic of Nigeria for all purposes. The plaintiff further prayed the court to issue a perpetual order of injunction restraining the first defendant Tinubu either by himself, his officers, agents, previous servants, or any other person acting under his command howsoever named, from either removing, suspending, or otherwise tampering with the tenure of the governor and deputy governor of Rivers State and indeed any other state in Nigeria. He equally sought an order of perpetual injunction barring President Tinubu either by himself, his officers, agents, previous servants, or any other person acting under his command howsoever named from appointing any sole administrator into any state government house in the 36 states of Federation for any purpose whatsoever. In the originating summons, the plaintiff prayed the court to determine whether, in view of the combined provisions of the entirety of sections 1, 5 sub 2, 180, 188, 189, 305, and 306 of the 1999 Constitution of the Federal Republic of Nigeria, the President has any constitutional authority to either remove, suspend, or otherwise tamper with the tenure of the duly elected governor and deputy governor of Rivers State. Upon the determination of the question, he prayed the court to declare that, upon an intimate reading and complete understanding of the entirety of sections 305 of the 1999 Constitution as amended, there is no other circumstance contemplated by the Constitution for the removal or interruption of the tenure of an elected governor and deputy governor of a state, except the circumstances contemplated under sections 180, 188, 189, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended. A declaration of this honorable court that in view of the entirety of sections 1, 5 sub 2, 180, 188, 189, 305, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended, the President of the Federal Republic of Nigeria has no constitutional authority to either remove, suspend, or otherwise tamper with the tenure of a duly elected governor and deputy governor of a state and appoint a sole administrator or any other substitutes howsoever called or described, such as the third defendant hearing for that state. A declaration of the Honorable Court that the purported suspension of the governor and deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025 is unconstitutional, null, void, and of no legal effect. Recall that on Wednesday, the 9th of April 2025, Vice Admiral Ibokete Ibas, the sole administrator of Rivers State, defied court orders by appointing administrators for the 23 local government areas. The sole administrator of Rivers State had approved the appointment of the administrators for the 23 local government areas of Rivers State less than 24 hours after a federal high court reportedly restrained him from doing so. The appointments, along with the reconstruction of previously suspended boards of agencies, commissions, and parastatals, were also announced in a special government announcement issued on Wednesday morning by the Secretary to the State Government, SSG Professor Ibibia Worika. His Excellency, the Administrator of Rivers State, Vice Admiral Ibokete Ibas, retired, CFRO has approved the appointment of administrators for the 23 local government areas of Rivers State. The statement reads, he has also approved the reconstruction of some boards of agencies, commissions, and parastatals earlier suspended. All appointments take effect from Monday, the 7th day of April 2025. The development comes amid legal uncertainties. Meanwhile, on Tuesday, Justice Adam Muhammadu of the Federal High Court in Port Harcourt in suit number FHC PHC CS 46 2025 granted an interim order restraining the sole administrator from making such appointments. The suit was filed by a civic group, PILEX Center for Civic Education Initiative, led by Courage Nsirimovu. Speaking to reporters, Nsirimovu expressed concern over the administrator's decision to proceed despite the court's directive. This is a blatant disregard for the rule of law, Nsirimovu said. We are witnessing a dangerous trend where court orders are treated as mere suggestions. This undermines the very fabric of democracy and governance. However, the list of appointed LGA administrators has yet to be made public. In a separate administrative shake-up, IBA has also nullified all pending procurement and tender processes conducted by ministries, departments, and agencies in the states. According to a prior statement by the SSG, the cancellation stems from the absence of an appropriation law following a recent Supreme Court judgment. All MDAs, which are the ministry, departments, and agencies in the states that carried out such tender processes, are directed to reform the fees collected from contractors immediately, the statement added. Just last week, IBA suspended all heads of MDAs in Rivers State with immediate effect, a decision that analysts say indicates a sweeping consolidation of administrative control.